January 22nd, 1973. A single day that would fracture a nation. Inside the United States Supreme Court, a silence fell. 9 justices prepared to speak a single name. A name that would ignite celebrations, fuel outrage, and redefine the very meaning of liberty. The name was Roe versus Wade. America would never be the same again. This was the America the world saw, a nation of prosperity and progress. But beneath the surface, a desperate, silent epidemic was raging. For countless women, an unwanted pregnancy was a death sentence. The only options were back alleys, unlicensed practitioners, and dangerous self-administered procedures. The numbers were staggering. Public health officials estimated over 1 million illegal abortions every year. Thousands of women never came home. These weren't just statistics. They were mothers, daughters, sisters, with nowhere else to turn. But a countercurrent was building. A new consciousness was taking hold. The civil rights movement had taught a generation how to protest, how to demand equality from their government. And women were listening. They began to organize, to speak out, to declare that the most personal parts of their lives were, in fact, political. Their rallying cry became, "The personal is political." They fought for equal pay, for equal rights, and crucially, for the fundamental freedom to control their own bodies and futures. And in Texas, one woman's desperation would give that roar a name. Her name was Norma McCorvey, but the world would know her only as Jane Roe. She became the lead plaintiff in a class action lawsuit representing all women similarly situated in Texas. Pregnant for the 3rd time, Texas law left her with no safe or legal options. She couldn't afford to travel. She couldn't risk a back alley. With a sense of destiny, then she met 2 young lawyers who saw a chance to challenge the law itself. Norma, desperate and with nothing left to lose, said yes. And in that moment, Norma McCorvey disappeared, and the legal legend of Jane Roe was born. On March 3, 1970, the lawsuit was filed. The defendant was Henry Wade, the Dallas County District Attorney, because it was his job to enforce the Texas statute. The claim was bold, that the law violated the U.S. Constitution. The lawyers, Sarah Weddington and Linda Coffey, pointed to a right not explicitly written down, the right to privacy. They argued this right was grounded in the 14th Amendment's concept of personal liberty and the 9th Amendment's reservation of rights to the people. It was a legal long shot based on a constitutional ghost. The battle lines were now drawn in a federal courtroom. On one side, Jane Roe, a symbol for every woman trapped by the law. On the other, the state of Texas, defending its power to protect what it saw as the sanctity of life. What began as a personal crisis for one woman was now a fundamental constitutional confrontation. A case that would climb all the way to the highest court in the land and into the heart of every American home. Armed with nothing but law books and conviction, Weddington and Coffey began building their case. Their strategy was twofold. First, prove the very real harm the law caused to women's lives and health. And second, anchor that harm in the solid ground of constitutional principle. They worked late nights, their office a small fortress of paper and purpose, preparing for a trial that would test every ounce of their skill. They were not just facing a local attorney. They were facing the full legal machinery of the state of Texas. The Attorney General's office assembled a team of seasoned lawyers. Their argument was simple, powerful, and rooted in centuries of tradition. The state's fundamental interest is in protecting potential life. For them, this was not a matter of privacy, but of public morality and safety. The three-judge panel listened intently in the federal courtroom. Weddington presented her arguments, weaving personal tragedy with constitutional theory. The state's lawyers countered with cold, hard legal precedent. The air was thick with unspoken implications. This wasn't just a hearing. It was a preview of a national conflict playing out in a small Texas courtroom. The weeks of waiting felt like an eternity, the case hanging in a fragile balance of hope and dread. Then, in June of 1970, the federal court's decision finally arrived. To the shock of the legal world and the state itself, the three-judge panel had agreed with Roe. In a stunning rebuke, they declared the Texas abortion statute unconstitutional, a violation of a woman's fundamental rights. For Sarah Weddington and Linda Coffey, it was a landmark against all odds victory, a validation of their radical constitutional argument. For the first time, a federal court had recognized the gravity of the issue. It seemed a new dawn was breaking. But the historic victory contained a fatal flaw, a legal technicality that would crush its human heart. In a cautious procedural move, the court refused to issue an injunction to block the law immediately. The ruling was stayed, suspended in a legal limbo pending the state's inevitable appeal. For the women of Texas, nothing had changed. Abortions remained a dangerous, clandestine act. And for Norma McCorvey, the named plaintiff, the irony was devastating. Her pregnancy had advanced far beyond the point of any solution. The case that bore her pseudonym had saved its symbol, but it had utterly failed the woman herself. With the Texas law still enforced by the state's appeal, the narrow path forward was now terrifyingly clear. Both sides filed their formal petitions, asking the 9 justices of the United States Supreme Court to weigh in. The case of Roe v. Wade was no longer a Texas matter. It was now docketed for the highest court in the land, a constitutional earthquake in the making. The local fight was over. The national battle for the soul of the nation's laws was about to begin. The Supreme Court's decision to hear Roe v. Wade was a starter's pistol that echoed in every town and city across America. The legal debate vanished, replaced by a raw public battle fought on the evening news and in the streets. Newspapers splashed the story across their front pages. Television news, now broadcasting in living color, brought this once taboo conflict directly into American living rooms. For the first time, ordinary citizens were forced to confront the issue, to pick a side not in a whisper, but in a roar that would define a generation. Overnight, Sarah Weddington and Linda Coffey were transformed. They were no longer just attorneys, they were now national symbols, carrying the hopes of a movement on their shoulders. They faced a barrage of media scrutiny, a whirlwind of flashbulbs and shouted questions. Every word they uttered was dissected, every legal strategy analyzed in the press. The pressure was immense. They had to be more than just lawyers. They had to be historians, philosophers, and unwavering advocates, all under the blinding, unforgiving hot lights of history. And waiting for them inside the silent marble chamber were the 9 men who held the ultimate power. This was not a monolith, but a collection of fiercely independent legal minds. There was Warren Burger, the cautious Chief Justice; William O. Douglas, the unwavering liberal firebrand; Potter Stewart, the pragmatic swing vote, who often held the balance of power in his hands; and the two newest justices, William Rehnquist and Lewis Powell, whose conservative philosophies would profoundly shape the court's direction for decades to come. On December 13, 1971, the marble halls of the Supreme Court fell into a profound silence. The historic first oral arguments in Roe v. Wade were about to begin. A young, determined Sarah Weddington stood up, facing the 9 justices. She was the youngest person in decades to argue before them. The justices, sharp and deeply prepared, immediately began firing questions like precision arrows. "Where in the Constitution is this right specifically enumerated?" they demanded. The future of reproductive rights in America now hung on the clarity of her answers, on her ability to build a bridge between a silent text and a screaming national need. After the arguments concluded, the nation waited for a decision. Weeks turned into months, but instead of a ruling, an unprecedented silence fell from the court. Behind the scenes, the justices were deeply, bitterly divided. The case was a political and legal minefield. With 2 new justices just appointed, the ideological balance was in flux. Finally, the word came down, not as a verdict, but as a stunning order. The case would be re-argued. Roe v. Wade was pushed to the next term, leaving a nation in limbo and proving that even for the Supreme Court, some questions were too monumental to answer quickly. On October 11, 1972, the lawyers returned to a changed court. The 2 new justices, Powell and Rehnquist, now sat in judgment, altering the dynamic in the room. This time, Sarah Weddington was sharper, more experienced. She framed the issue not just as privacy, but as essential liberty, a woman's right to equal citizenship and control over her own destiny. The justices dug deeper, pressing on the most difficult question. If the state's interest is in protecting life, at what precise point does that life begin? There were no easy answers, only the grim weight of a decision that would define the boundaries of life, liberty, and the power of the state for generations to come. The task of writing the majority opinion fell to Justice Harry Blackmun, a former lawyer for the Mayo Clinic. He was a man steeped not just in law, but in medicine and history. He retreated into a cavern of law books and medical journals, searching for a line that could divide the undividable. He studied ancient texts, English common law, and modern embryology, searching for an answer that had eluded philosophers for centuries. The weight was immense. In his hands, he held not just a legal opinion, but the future of millions of women and the moral conscience of a nation. Every word would be etched into history. To the fall and winter of 1972, the opinions circulated among the justices. The debates were fierce, the language carefully negotiated word by word. A fragile majority was forged. Then, on January 22, 1973, the decision was announced. The court had ruled 7-2 in favor of Jane Roe. With immense gravity, the right to privacy, the court declared, was broad enough to encompass a woman's decision whether or not to terminate her pregnancy. In one sweeping ruling, the Supreme Court had invalidated abortion laws in 46 states, redrawing the map of American liberty and igniting a cultural firestorm that would burn for half a century. The morning of January 23, 1973, dawned on a different America. The decision was no longer a legal theory, it was the law of the land. In doctors' offices and clinics, phones began ringing off the hook. Women who had lived in fear and secrecy now had a constitutional right to a safe, legal procedure. But in churches and state houses, a different sound echoed, the sound of organizing, of vows to fight back, of a movement being born in opposition. The ruling was meant to settle a question. Instead, it opened a fault line in American society that would only deepen with time. Politicians in state capitals across the country scrambled to respond. The Supreme Court had spoken, but it was state legislatures that would become the new battleground. Almost immediately, states began testing the limits of the ruling. They passed laws requiring mandatory waiting periods, parental consent for minors, and bias counseling, all designed to restrict access without openly defying the court. This strategy, a slow chipping away at the right, would become the blueprint for the opposition for the next 50 years. The war was not over. It had simply moved to a new front. For women, especially the poor and rural, the legal right was one thing. Access was another. A maze of new state restrictions meant that for many, a safe abortion was still out of reach. A right in name, but not in reality. And then, the conflict turned violent. Clinics were firebombed in the dead of night. Doctors who performed abortions received death threats. With grim gravity, the most intimate of personal decisions had become a national battleground, and now, a war zone. For millions of Americans, the Roe decision was not a victory for liberty, but a profound moral catastrophe. They saw it as the sanctioning of what they sincerely believed was the taking of innocent human life. This conviction fueled a powerful and rapidly growing social movement. They organized not as political operatives, but as moral crusaders. Visualizing the movement, they held massive rallies, marched on Washington by the hundreds of thousands, and built a powerful grassroots network that would eventually reshape the entire American political landscape. Their rallying cry, "Right to Life," would echo from church pulpits to the halls of Congress, ensuring the debate would never fade away. And so, the battle lines were drawn for a war that would span generations. Roe v. Wade became more than a legal precedent. It was a fault line in American culture, a litmus test for politicians, a defining issue for the courts. Building through the decades, the 1980s, the 1990s, the 2000s, each decade saw the conflict intensify. The Supreme Court reaffirmed the core of Roe in 1992's Planned Parenthood v. Casey, but allowed states even more power to restrict it. The Supreme Court, looking to the future, the question was no longer if, but when. With every new Supreme Court appointment, the balance of power shifted slightly. The nation held its breath, waiting for the day the foundational case would be challenged once more. The firestorm of 1973 was not a one-time event. It was the beginning of America's unending war over life, liberty, and who gets to decide. By the 21st century, the fate of Roe no longer rested with legal scholars, but in the brutal arena of presidential politics. Every Supreme Court vacancy became a national referendum on abortion. Potential nominees faced a single defining question in confirmation hearings. How will you rule on Roe? Their answers, or their careful evasions, would determine their confirmation and alter the course of American law for a generation. The political strategy of decades reached its climax with a single presidency. Donald Trump's 3 appointments, Gorsuch, Kavanaugh, and Barrett, reshaped the court. As a justice's portrait locks into place, the long-standing conservative majority was now not just a possibility, it was a solidified reality. The ideological balance had fundamentally shifted. For the first time since 1973, the complete overturning of Roe v. Wade was no longer a matter of if, but when. The final battle was now inevitable. The challenge arrived in the form of a Mississippi law known as the Gestational Age Act, which banned most abortions after 15 weeks. The case, Dobbs v. Jackson Women's Health Organization, was not a request to tweak the edges of Roe. It was a direct, deliberate provocation to the court's precedent. The state of Mississippi did not ask for a mere adjustment. It presented the justices with a stark choice: uphold Roe or overturn it completely. The trap was set. The stage was now prepared for the final, decisive confrontation. On December 1st, 2021, the Supreme Court heard oral arguments in Dobbs v. Jackson. The atmosphere was electric, the stakes unimaginable. The conservative justices appeared openly skeptical of Roe's foundational logic. They questioned its historical basis and its workability as precedent. Why should this court be the arbiter rather than Congress, rather than the states? For the first time in decades, a majority on the court seemed willing to not just limit Roe, but to consign it to history. The unthinkable was now being discussed in open court. On May 2, 2022, an unprecedented event shook Washington. A draft of the Supreme Court's opinion in the Dobbs case was leaked to the press. It revealed that the court was poised to do the unthinkable: overturn Roe v. Wade entirely. Justice Samuel Alito's draft opinion called Roe egregiously wrong from the start. The leak created a firestorm, but the outcome was already sealed. On June 24, 2022, the official decision was released. In a 6-3 ruling, the Supreme Court overturned Roe v. Wade, eliminating the constitutional right to abortion after nearly 50 years. The war that began in 1973 had reached its climactic, devastating end. The moment the Dobbs decision was announced, the American map transformed in a heartbeat. A constitutional right, recognized for nearly half a century, vanished overnight. In 13 states, trigger laws snapped into effect, instantly banning abortion and forcing clinics to close their doors for the first time in decades. For millions of women, their fundamental rights were now determined by a confusing, fractured patchwork of state laws. Your access to care now depended entirely on the fate of your zip code. Behind the legal arguments and political headlines were human beings facing impossible decisions. Women with wanted pregnancies that had gone tragically wrong. Victims of rape and incest. Mothers who could not afford another child. Their personal tragedies were now compounded by a labyrinth of new state laws. Organizations created underground networks, helping women travel thousands of miles across state lines for medical care that was once available in their own communities. A desperate journey for a fundamental right. Politically, the overturning of Roe was an earthquake that shattered decades of assumptions. It instantly became the most volatile force in American democracy. In the 2022 midterm elections, the issue of abortion rights defied all predictions. Voter turnout surged, with the debate mobilizing Americans across the political spectrum. The so-called red wave never materialized. Instead, voters in several states directly passed ballot measures protecting abortion access, sending a clear message to lawmakers. The court's decision to return the issue to the political arena had succeeded, but it unleashed a political power that neither party could fully control. So what is the final legacy of Roe v. Wade? For 50 years, it was more than a law. It was a symbol of an expanding concept of liberty. It represented a promise of bodily autonomy and stood as a beacon for women's rights. Its overturning marked the first time the Supreme Court had ever revoked a fundamental personal freedom. Its epic story reflects the ongoing American experiment itself, a continuous, often painful debate over the meaning of freedom, the role of government, and the delicate balance between individual rights and deeply held moral beliefs.